Good day, world. This is Catherine Frasco, your newscaster for today. Sexual harassment is a type of harassment that involves the use of explicit or implicit sexual overtones. According to the Equal Employment Opportunity Commission or EEOC, sexual harassment includes unwelcome sexual favors and other verbal or physical harassment of a sexual nature in the workplace or learning environment. Sexual harassment by an employer is a form of illegal employment discrimination. For many business or organizations, preventing sexual harassment and defending employees from sexual harassment charges have become key goals of legal decision-making. In RA 7877, it mandates that the employer or the head of the work-related educational or training environment or institution must provide the procedures for the resolution, settlement, or prosecution of acts of sexual harassment. The employer must create a committee on decorum and investigation of cases on sexual harassment.
When is sexual harassment committed in a work-related environment?
In a work-related environment, sexual harassment is committed when the sexual favor is made as a condition in the hiring or in the employment, re-employment, or continued employment of said individual, or in granting favorable compensation, terms, condition, promotions, or privilege, or the refusal to grant the sexual favor results in limiting, segregating, or classifying the employee which in any way would discriminate, deprive, or diminish employment opportunities or otherwise adversely affect the employee. The above acts would impair the employee's rights or privilege under the existing labor laws, or the above acts would result in an intimidating, hostile, or offensive environment for the employee. This act shall be known as the Anti-Sexual Harassment Act of 1995.
Section 2, Declaration of Policy. The state shall value dignity of every individual, enhance the development of its human resources, guarantee full respect for human rights, and uphold the dignity of workers, employees, applicants of employment, students, or those undergoing training, instruction, or education. Towards this end, all forms of sexual harassment in the employment, education, or training environment are hereby declared unlawful.
Section 3. Work, education, or training-related sexual harassment defined. It is committed by any other person who having authority, influence, or moral ascendancy over another in a work or training or education environment. It demands, requests, or otherwise requires any sexual favor from other. Regardless, the request for submission is accepted by the object of the said act. In a work-related or employment environment, sexual harassment is committed when the sexual favor is made as a condition in the hiring or in the employment, or in granting favorable compensation, terms, condition, promotions, or privilege, or the refusal to grant the sexual favor results in limiting, segregating, or classifying the employee which in any way would discriminate, deprive, or diminish employment opportunities, or affect the employee. The above acts would impair the employee's rights or privilege under the existing labor law, or the above acts would result in an intimidating, hostile, or offensive environment for the employee. In an education or training environment, sexual harassment is committed when against one who is under the care, custody, or supervision of the offender, against one whose education, training, apprenticeship, or tutorship is entrusted to the offender. When the sexual favor is made a condition to the giving of a passing grade, or the granting of honors and scholarships, or the payment of a stipend, allowance, or other benefits, privilege, or considerations, or when the sexual advance result in an intimidating, hostile, or offensive environment for the result, trainee, or apprentice. Any person who directs or induces another to commit any act of sexual harassment as herein defined, or who cooperates in the commission thereof by another without which it would not have been committed, shall also be held liable under this act. Section 4. Duty of the employer of head of office in a work-related education or training environment. It shall be the duty of the employer or head of the work-related, educational, or training environment or institution to prevent or deter the commission of acts of sexual harassment and to provide the procedures for the resolution, settlement, or prosecution of acts of sexual harassment. The employer or head of office shall promulgate appropriate rules and regulations in consultation with the jointly approved by the employees or students or trainees through their duly designated representatives, prescribing the procedure for the investigation or sexual harassment cases and the administrative sanction. Administrative sanctions shall not be a bar to persecution in the proper courts for unlawful acts of sexual harassment. The said rules and regulations issued pursuant to this section A shall include, among others, guidelines on proper decorum in the workplace and educational or training institutions. The committee shall conduct meetings as the case may be with other officers and employees, teachers, instructors, professors, coach, trainers, and students or trainees to increase understanding and prevent incidents of sexual harassment. In the case of a work-related environment, the committee shall be composed of at least one representative, each from the management, the union, the employees from the supervisory rank, and from the rank of file employees. In the case of the educational or training institution, the committee shall be composed of at least one representative from the administration, the trainers, teachers, instructors, professors, or coaches, and students or trainees.
Section 5. Liability of the employer, head of office, educational or training institution. The employer or head of office, educational training institution shall be solidarily liable for damage arising from the acts of sexual harassment committed in the employment, education, or training environment. If the employer or head of office, educational or training institution is informed of such acts by the offended party and no immediate action is taken thereon.
It means that the law requires the employer or head of office to prevent sexual harassment acts from occurring and to provide procedures for the resolution, settlement, or prosecution of sexual harassment.
Section 6. Independent action for damages. Nothing in this act shall preclude the victim of work, education, or training-related sexual harassment from instituting a separate and independent action for damages and other affirmative relief. No other person can defy or contradict the act stipulated. Hence, it is crucial and privileged to learn in regard with identifying sexual harassment to mitigate damages and prevent predicament events. A person has the right to acquire sexual harassment awareness to withstand what should have been done in order to reinforce the deterrence of a particular entity from committing violence act unlawfully. The victims of harassment frequently suffer harassment-related psychological injuries, such as including depression, anxiety, headaches, lowered self-esteem, sleep disorders, weight loss or gain, and sexual dysfunction. Make it clear to the harasser that the offensive behavior is unwelcome. Report the harassment to management and ask that something should be done to stop it. Report the harassment to a person with decision-making authority. Section 7. Penalties. Any person who violates provisions of this act shall, upon conviction, be penalized by imprisonment of not less than 1 month, nor more than 6 months, or a fine of not less than 10,000 pesos, nor more than 20,000 pesos, or both such fine and imprisonment at the discretion of the court. Any person who infringes the specified provision of the law shall be penalized by imprisonment for a term of 1 month to 6 months, whereas in the amount of between not less than 10,000 pesos to 20,000 pesos as the compensation of unlawful act prohibited, or both. The prescribed compensation of guilt depends on what has been done in the discretion of the court.
Section 8. Separability Clause. If any portion or provision of this act is declared void and unconstitutional, the remaining portions or provisions hereof shall not be affected by such declaration. The provisions of this agreement are deemed to be separable to the extent that if and when a court of last resort adjudges any provisions of this agreement in its application between the union and the undersigned employer to be in conflict with any law, such decision shall not affect the validity of remaining provisions of this agreement, but such remaining provisions shall continue in full force and effect. Provide further that in the event any provision or provisions are so declared to be in conflict with a law, both parties shall meet immediately for the purpose or renegotiation and agreement on provision are so invalidated.
Good day everyone, I'm Casey Batikin and I'm discussing about Section 9 and 10. Section 9, Repealing Clause. All laws, decrees, orders, rules and regulations or other issuances or parts thereof inconsistent with the provisions of this act are hereby repealed or modified accordingly, meaning pwede siya mabawi, mausab, or mapunan. Section 10, Effectivity Clause. This act shall take effect 15 days after its complete publication in at least 2 national newspapers of general circulation. It means after 15 days of completing the news publication from at least 2 national newspapers, this law shall take effect. That's all, and thank you.